Started here. There we go. Okay. We'll go to the picker wheel if we need to, but we'll see. We'll see if we need to. Um, yeah, thanks, Trina. Yeah, this is I came straight from this meeting, and so I didn't have time to change into something more standard, Professor. Uh, oh, let's see. Niche, you're asking. Oh, because you would want to leave, you have to leave the meeting. Uh, well, if you need to leave slightly early, I think that should be okay. Thank you very much. Uh, all right, let's go ahead and start right at the beginning here. And as usual, I've got a bunch of questions for you guys. So let's share I wonder what I look like with the suit on. Oh, not bad. Yeah. All right. So let's talk a little bit about the different interpretations of the Constitution according to Dworkin. Um, so right at the beginning, I talk about this role of the Supreme Court, about the how basically everybody accepts that it's the purpose of the Supreme Court nowadays, and it has been since 1803, to serve as the body which determines the limits of each branch of government. So the Supreme Court is entrusted with this. It's supposed to say what the law is. And part of that is saying what Congress can do and what the president can do and what the courts can do. But then this leaves open a pretty big question that you might view all of Supreme Court case law as answering, which is how do we actually exercise these powers? Um, yeah. So uh, Dworkin talks about historicism and he also talks about passivism. So let's start with historicism. Can anybody tell me what historicism is? It's this view that he criticizes, but what is he, before we get to the criticisms, what's the view? Go ahead, Umul.
Is it like when they interpret the Constitution, they need to think about like the intentions of the people who created the Constitution?
Good. Yes. It's the idea that our interpretation of what different branches of government can do, what they're empowered to do based on what the Constitution says, um, it's that interpretation has to be limited to what the intentions of the framers of the Constitution were. So, for a lot of the Constitution, that is the people who attended the actual Constitutional Convention back in the 1770s. But for some of the Constitution, particularly the amendments added after the Civil War, we'd be talking about people writing in the mid 1860s. So both both of those, though, the historicism says the intentions of those guys are the things that matter. Now, he makes a distinction between a kind of weak historicism and a strong one. Can anybody tell me the difference between those two? Yeah, go ahead, Nish.
Is it like strong historicism says judges must strictly follow the frame's specific intentions, while weak historicism treats those intentions as important but not controlling,
Hmm.
allowing interpretation to consider broader principles and later developments.
Okay. Yeah, I think that's about right, especially about the strong version. So if we were going to make a distinction here, um, so the way that Dworkin puts the weak version, so the strong version is pretty much exactly what you just said, right? It's that when we're trying to determine whether a statute should be overturned or retained, whether it's compatible with the Constitution or forbidden by the Constitution, we really have to look at what the framers intended. Whether the statute should be overturned according to those intentions or not. And the weaker version is basically that if the framers would have expected that such a statute would be overturned, then it should be overturned. Now, they may not have had express intentions that this kind of statute is forbidden, but if they would have expected that this kind of statute would be overturned, even if it wasn't expressly considered, that's the weaker version. They would say that's really what we should be looking toward, right? So it's about expected versus intended. These are both versions of historicism, which say that the original intentions or expectations of the founders are what matter for interpreting the Constitution. Good. Did you want to follow up on that, Niche?
Um, um, I mean, if okay, so like for weak historicism, like if we look at what the framers would have expected the Constitution to apply to, even if they didn't specifically think of the exact case. I don't know if I'm like being able to like put it into the right words. I don't know. I can't process at this point. I don't know. I'm so sorry.
Yeah, no. Let me expand on it. So he doesn't really give an example here, but the one I had in mind is something like, um, well, this would be like something like Miranda rights. So when you're arrested, the police have to say you have the right to remain silent. Anything you say or do can be used against you in a court of law. You have the right to an attorney. If you cannot afford one, one will be appointed for you. Um, and then they ask, like, do you understand your rights as I've read them to you? That's the Miranda warning. We're going to go into that in more detail when we cover Miranda versus Arizona. It's one of the three cases that we're covering in this class explicitly. But that that is not anywhere in the Constitution. Um, Now, because it's not anywhere in the Constitution, but instead derived from the Fifth Amendment, arguably the strong version of historicism would disapprove of it. That is, nobody had this in mind when they wrote the Fifth Amendment. And because of that, it would be a kind of unconstitutional grabbing of power from the Supreme Court to require police to do that when they're arresting you. Now, arguably, the weak version might be able to account for something like this. If we thought, well, uh, allowing the police to hide the fact that you have rights and not make you aware of them kind of makes your Fifth Amendment right against self-incrimination kind of pointless. It renders it a kind of dead letter for the vast majority of people who don't have legal training and can't understand their rights directly, unless it's explained to you. And so, arguably, the weak version might be able to account for this. You might be able to say, look, if you look at what the original framers intended, it was that people would understand what their rights are. And so, any system which allowed the police to hide their rights, to not tell people what their rights are, might be a system they would expect to rule unconstitutional. So the weak version might be able to account for holdings like you have in Miranda versus Arizona. Whereas the strong one, it'd be hard to say that it does, right? So there is a difference between these two positions. The weak one maybe accounts for some of the Supreme Court jurisprudence that we've seen in the 20th century and the 21st century. But the strong one really would require overturning pretty much every major Supreme Court decision that involves our rights in the 20th century and the 21st. Okay. So hopefully that makes some kind of sense, right? That's just me trying to give an example of one place where these two views might diverge. Okay, so let's talk about the problems with this view. Before I get to that, though, let me just mention the purpose of this view, or what this view accomplishes, either in its weak or strong form, is supposed to be a kind of stability that if we know what the original framers intended, or at least what they expected would happen, then we will know how whether a given law is constitutional or not in a kind of stable, predictable way. And if we didn't adhere to the original intentions of the framers, or their at least their expectations, this view says we would be really throwing the legal system into chaos because people wouldn't know if they go before a judge whether that judge was going to throw out all past precedent about what these intentions were and decide something totally different. You might brief a case for a judge and say, look, this is what precedent says you should do. And then the judge decides, no, I'm going to do something different because there's other better results I'm interested in. And therefore, I'm not going to follow this precedent. So this is the broad argument for historicism. Yep, I took you off the wheel there, Niche. Thank you. Let's see, Frankie, you're saying kind of like the Second Amendment with their intentions back then compared to how guns are right now. Yeah, I mean, the Second Amendment's an interesting example because the weak or the strong version of historicism would say, look, the framers didn't express any intention about whether ordinary people can have, um, high-powered assault rifles that can easily, quickly shoot 30 rounds in a magazine and be reloaded very quickly. Because what they were using back then was muskets. They couldn't have imagined it. But because they didn't express any intention about the future of, weaponry, there couldn't possibly be any law which would prevent, like any law which would prevent civilian ownership of these kinds of weapons is clearly unconstitutional because the framers didn't intend for there to be restrictions on any kind of firearm, or they would have mentioned those restrictions. The weak version might have more wiggle room on this. The weak version could say something like, well, here's an argument that the framers may have expected that over time, weaponry would get more powerful and more easy to use and more deadly. And you might be able to make an argument that you'd still have to appeal to historical evidence about this, but you might be able to make an argument that more restrictions would have been expected by the framers of the Constitution had they known that our weaponry would get so much more deadly. I wouldn't say it necessarily goes either way because I'm not totally sure if there is that historical evidence about how they would have interpreted advances in firearms technology. But at least the weak version gives you a little more wiggle room. All right. So the other important question, the important question I want to get back around to, though, is what's the problem with historicism? It's supposed to give us a degree of stability in the legal system. It's supposed to be reflective of what the original framers' intentions were. So why is it not the best approach to the Constitution, according to Dworkin? Go ahead, Chloe.
I believe based on the reading, they said it was two things missing, which is justice and fairness.
Yeah. Okay. Yeah. Can we expand on that? So what does he mean by justice? This is a kind of value he thinks is inherent in the Constitution.
So fairness being, everybody's treated equally, in justice, I'm a little shaky on, meaning that if somebody was dealt a bad card, that they could be redeemed, basically.
Okay. Okay. I think we can get a little more specific, but I think you're in the right area here.
Okay.
Yeah. What is justice? These take on a kind of specific meaning for Dworkin.
I'm a little shaky on that. Somebody else can hop in and help.
Yeah, any other thoughts about this? What is justice and why does historicism not account for it? Yeah, go ahead, Umar.
I was thinking of it as like justice being, I think it was in the slides, it was like the interpretation must respect like people's rights. And then when you think about like historicism, it's more about like the intention of the framers of the Constitution. So you can't really account for both at once.
Okay. So yeah, does justice according to Dworkin is all about respecting people's rights. If we have a right to something, a just legal system is something that respects that right. Um, Whereas fairness has to do with the majority getting what it wants. Um, and so these two important values seem to come into conflict in a lot of cases. A lot of the most interesting Supreme Court cases involve a conflict between majoritarian impulses. That is, the legislature elected by the people has chosen to do this thing, and people's individual rights against state infringement. So let's talk about why historicism fails to account for justice properly, because this is the heart of Dworkin's critique of historicism. And remember, we see this kind of argument made all the time about how really the Supreme Court, when it hands down rulings like Brown versus Board of Education or Miranda versus Arizona, that like it is not respecting the will of the people. And Dworkin is saying, look, or it's not respecting the initial intentions of the founders. That's another possible critique. And Dworkin is really saying, well, look, we can't base all of our interpretations on the initial intentions of the founders, because that fails to account for these two important virtues of our political and judicial system, one of which is justice, which is respecting people's basic rights. So let me talk about this. So he thinks that really, if we talk about the strong version of historicism, the strong version is incompatible with pretty much everything that the Supreme Court has done in the 20th century and the 21st. The strong version implies, for example, that Brown versus Board of Education was wrongly decided, because it is a Supreme Court case where they said separate is not equal, and the requirement that everybody be treated with equality before the law means that you cannot have separate school systems for Black and white people. But of course, the strong version of historicism would say, look, the founders of the 14th Amendment in the 1860s were aware of segregated schools and clearly did not believe that the 14th Amendment implied that we needed to get rid of segregated schools. For Dworkin, that's just a kind of reductio ad absurdum, that if all that mattered was what these guys in the 1860s thought, and nothing about our contemporary society or the values that's expressed in it matters, then we would be forced to accept that segregation is still constitutional. But he thinks that's just obviously false. I think there's another possible and interesting, even more interesting argument that applies arguably to both the weak and the strong versions, which is not just that they get the wrong answer on certain kinds of court cases, but that historicism is kind of internally inconsistent, because historicism says that the only thing that matters for interpreting the Constitution is the intentions of the framers. Well, the framers, though, did not view themselves as creating a document or a political organization whose sole purpose it was to reflect their own intentions. That is, the Constitution doesn't just say, hey, we here sitting in this hall in Philadelphia in the 1770s, we here sitting here intend for this stuff to happen. And anybody that acts contrary to our intentions is wrong. Instead, if you read the Constitution, especially if you read the Bill of Rights, which was passed and added to the Constitution immediately after, you will find that the Constitution is full of people's rights. You have a right to bear arms. You have a right to free speech. You have a right to express your religious views. You have a right to not have soldiers quartered in your house. You have a right against unreasonable search and seizure, against self-incrimination. The Constitution has tons of rights that adhere to individuals against majoritarian rule. And it would make little sense for the founders to enumerate all those rights and yet have the right and yet conceive of the right way of interpreting the Constitution they created as being only about their intentions. Instead, the Constitution seems to be about rights. And so we should be interpreting whether a law is constitutional or not based on whether it conforms with those basic rights as expressed in the Constitution. And those basic rights are not always compatible with what the literal intentions of the framers were. So I hope you guys can see how this is kind of starting to connect with some of the groundwork that Dworkin laid in the first few chapters of this book, where he's talking about constructive interpretation. That what matters is not the intention of the person who originally wrote something, but rather the kinds of values or principles that thing they wrote expresses. And so the Constitution expresses certain values, expresses certain commitments to certain kinds of individual rights. That's what matters, not the intentions of the people who wrote it, according to Dworkin. Bears don't actually have arms. Yeah. So, yeah. Okay. So this is supposed to be an indictment of historicism because historicism, he thinks, fails even on its own lights. Even if we take the intentions of the founders to be the thing that really matters, the founders didn't intend for us to only care about their intentions, right? They intended for us to care about the values which are present in the document they wrote, and that the values that are expressed by that document. And those may outstrip the intentions of the founders because they simply didn't understand the way our society would evolve, or hadn't fully thought through the implications of the rights that we find present in the Constitution. So this is why he thinks historicism is certain to produce incoherence in the constitutional scheme. And it basically is tantamount to denying that the Constitution expresses principles. So this is another, I should say, the latter is really what I was just talking about. The former is another kind of argument that Dworkin makes, which is like, look, the framers had all kinds of different views and intentions with writing what they wrote in the Constitution. There isn't just one set of intentions. It's not like they all had a hive mind and worked together. There were competing political influences that all led to the compromise that ended up being the Constitution. And the same is true for the post-Civil War amendments. These were the product of a long political fight. If anybody ever sees the movie Lincoln, that's a movie in large part about the abolition of slavery and the fight for the 13th and the 14th Amendments in particular, which were passed after the Civil War. It was a political fight, and not everybody that signed on to it all had the same intentions. Okay, so these are his criticisms of historicism. So let's move on to, so he thinks the intentions of the founders, they only matter insofar as it's obvious that the founders intended for us to have rights. And that's what the Constitution expresses. So we should be worried about those rights, not what their intentions were. Go toward the thing that the document creates or emphasizes, or the value that's present in it, not the literal intentions of the author of that document. Okay, let's talk about passivism. So here I'm going to ask you guys another question. We'll go to the picker wheel if we need to. So passivism, what is this view? It's another view about interpreting the Constitution. It tells us something? What does it tell us? I'm going to spin the wheel. See if we got. Oh, Brian came up, and then I'll ask you the next question, Jeffrey, if Jeffrey's here. Go ahead, Brian.
Yeah, so I guess would it be when it comes to the decision that judges should, I guess, sort of remove themselves and be out of the way when it comes to the decision making?
Okay. Who would get in there if it wasn't him or if it wasn't them? Like, who would be making the decisions if it's not judges?
Probably, um, yeah, I'm not.
Hmm. Anybody have a thought? Who, if judges are getting out of the way, who are they getting out of the way for? Isaac?
Think it's more of the people that people vote for, the legislators, everyone that's elected.
Good. Yeah, the legislature. And sometimes the president. But yeah, the people who are elected. Um, so on this view, what judges should be doing is deferring to the will of the people. And the argument is, well, judges, in some cases, judges are elected, like state court judges are often elected. But at the federal level, the district courts, the Federal Circuit Court of Appeals, the Supreme Court, these are all appointed positions. They're appointed by the president with the advice and consent of the Senate. So there's not a direct democratic check on who gets into these positions. Um, in in part, this is because the idea is, well, we're going to have the most competent lawyers selected by the people have selected. So we're not going to just like have the rabble selecting who gets to be a judge. Instead, there's a more abstracted process. So you get people that are a little more technocratic, that have a little more training, people with a little background. And those people are going to be better equipped to make these kinds of decisions. But the implication of that is that anytime they make a decision that runs contrary to what the people want, it looks like the sort of founding idea of our country, which is that the people should get what they want, that the majority should, if we vote and the majority says this is what we're doing, then we just accept that. So pacifism basically says the Supreme Court should not get involved in overturning the will of the people unless it's absolutely necessary. And I think it's important to emphasize that this view is, I think often people take like a conservative approach to if they're trying to understand what it is to be a conservative on the Supreme Court, for example, they will conflate these two things because conservatives are often both historicists and pacifists. They think the original intentions of the founders are the only thing that matters, and the courts should get out of the way of the will of the people. But that's not always the case. Sometimes, it depends on the specific controversy that the court is asked to solve. So sometimes justices that are conceived of as more liberal are more pacifist or more historicist. Sometimes justices that people conceive of as conservative are not historicist and not pacifist. So these can shift, and it's important not to conflate them. They're two different views on what judges should be doing. And you could be a pacifist and a historicist if you think the original intention of the founders matters and we should generally get out of the way of the people. Or you could be a non-historicist like Dworkin and think, well, what matters is not the intentions, and a non-pacifist like Dworkin who thinks there are lots of cases where the court is the legitimate backstop protecting people's basic rights against majoritarian influence. Okay, so good. Thank you, Isaac. That was good. Okay, so for pacifism to be right, he thinks it would have to best serve the values that our Constitution expresses. And he thinks that the values our Constitution expresses are at least justice and fairness. So, justice, he thinks, is respecting people's rights, and fairness is that we must reflect the convictions that are dominant in the community as a whole. Excuse me. So let's talk a little bit about why pacifism does not do this. So, what's the problem, according to Dworkin, with saying that judges should defer to the legislature? Yeah, go ahead, Brian.
They might allow laws that actually violate the Constitution.
Yeah. Okay. So they might allow laws that violate the Constitution because we might have a basic a basic right of some kind that the legislature is not respecting. If the legislature passes a law that says you're not allowed to express your opinion on the street corner anymore, that'd be a violation of the First Amendment. And for a judge to say, well, look, that's what the will of the people says. So the will of the people, the majority of people passed this law, and so you can't express yourself anymore. That would be running contrary to what the First Amendment says, the value implicit in the First Amendment that we should all have freedom of speech. Okay, so there's another important criticism of pacifism. Anybody have that? Yeah, Uma?
Is this related to the fact that like it's like majority voice being
Yeah.
eliminated?
Okay. What's the problem with it being a majority? Like, why would that not necessarily respect the basic rights we have?
I think that wouldn't just include like everyone in that conversation. So the minority loses in this instance their rights, technically.
Yeah. So if the government says you're not allowed to criticize this policy we have, and well, the majority of people presumably voted for the legislature which has put this into power, has passed this law. So the majority of people probably agree that you shouldn't criticize this policy. But of course, there's a minority of people who want to criticize the policy. And by virtue of being the minority, they don't have their wills effectively expressed in the legislature. So the legislature, by its very nature, cannot properly respect certain kinds of basic anti-majoritarian rights because it always expresses the will of the majority. It's built into the way it operates. The minority will never have its political will expressed in any effective way like the majority will. So just by virtue of being a minority, they're always going to be outvoted. So we shouldn't expect that a kind of narrow majoritarian reading of the Constitution that pacifism would suggest is actually going to respect people's basic rights. Those rights are, in their nature, anti-majoritarian. And so when the majority passes stuff, it's probably going to infringe on those things, or it has a very good likelihood of doing so. So we shouldn't expect that the legislature is actually going to respect people's rights properly. Yeah, Marcel is saying the legislature must serve political virtues that benefit the judicial system. Yeah, so I mean, one of those political virtues is justice, and he thinks that deferring on these things to the legislature doesn't respect people's basic rights. So let's see. Do either of you guys have a follow-up, or are your hands up? Oh, okay. So we covered that pretty well. Okay, let's talk about fairness. So fairness, according to Dworkin, we go back, scroll back to this. Fairness is an interpretation of the Constitution must reflect the convictions that are dominant in the community as a whole. That's what fairness is supposed to be. So why is a majoritarian reading of the Constitution, a pacifist reading, not reflective of fairness? We might initially think, of course it's going to be reflective of fairness. It reflects the majority's opinion, right? Like the right, okay, let me expand on this. The right interpretation of the Constitution, according to pacifists, is one that says, look, we should respect the will of the people and judges should get out of the way. According to Dworkin, this does not respect a basic political value inherent in our Constitution, which is fairness, that an interpretation of the Constitution must reflect the convictions that are dominant in the community as a whole. So, how does it not respect fairness? Yeah, Carmel?
Is it that, is this kind of what you were saying earlier about how the majority decision making just overrides the rights of the minorities? And in a fair political system, Dworkin believes that it must be principled and not just democratic. So justifying decisions like has to respect people as equal, even though the majority might want something different.
Okay.
Okay.
Yeah, I think that's a pretty good explanation of it. Um, let's see what I can add to it. Yeah. Um, so he thinks that, so going over the slide, right? Does a narrow majoritarian view of the Constitution better serve fairness? Well, he thinks only if fairness demands that a majority of voters be constrained by the principles they themselves endorse. So his idea is that the principles that we endorse as members of this society include basic rights, like procedural fairness when you're put on trial. Like the Constitution clearly lays out a bunch of these rights that are supposed to be resistant to majoritarian impulses. So if we're interpreting what these rights mean, we can't just stand back and go, well, look, the legislature passed this. So we're not going to get in the way of that because they reflect the will of the people and we're just appointed judges. Because the will of the people can't be just, you can't take the temperature of the will of the people simply by assessing a single law that might, in the end, conflict with the basic values of the people. Like, we agree generally that we all ought to have free speech. So if a majority of people passes a law which says, actually, you shouldn't have free speech in this particular scenario, that law, even though this is kind of hard to understand, but that law, even though it reflects the will of the majority, doesn't reflect the basic principles that that majority also accepts. So sometimes, like, the majority can contradict itself without realizing it. It can accept or pass a law that conflicts with the basic principles that it itself accepts. And so this narrow reading allows for a lot of conflict like that, where we end up contradicting ourselves as a body politic by passing laws which undermine our own basic rights. Go ahead, Marvin.
Hi, Professor. Yeah, I had a question because I'm a little confused. So I just wanted to get clarity. So according to pacifism, if that's correct,
Mhm.
judges are basically supposed to stay out of, I guess, executive decision making because we have to follow the will of the people. However, as you said, the president does appoint, you know, judges and all those different type of positions. So what's confusing me is what would be the power of the judge? Because I thought the power of the judge was to, like, enforce these types of things. But however, we're supposed, according to Dworkin, we're supposed to follow the will of the people. But then you also just said, the people can also contradict themselves too, very quickly as well.
Yeah. So the pacifist reading of what the judge's role would be like a pretty narrow job of applying the law that was passed by the legislature or the, administrative procedures promulgated by the president, um, to specific cases. It would say, look, the law says you can't criticize this particular thing. Okay, is this person criticizing that particular thing? Okay, guilty, right? Send him to prison.
Yeah.
And Dworkin is saying that's not what the judge is supposed to do. If we're interpreting what the Constitution says, you shouldn't always just defer to what the majority is saying from the legislative. Because sometimes what the majority says is in conflict with the basic values that are present in the Constitution.
Yeah.
Yeah. Yeah. Okay. Hopefully that makes some kind of. I think that was a good question because, like, what's left over if we're raging pacifists? What's left over for
Yeah.
judges to even do?
Yeah, that's why I was like, I mean, I absolutely agree with Durkin because, the Constitution was made to, give us, the people, our rights, give the majority their rights. But, where's like the middleman? Like, or who would be the middleman in this situation now?
Yeah. Well, I
When
mean, if judges aren't doing it, then and really nobody else is doing it.
Like, yeah. Well,
Yeah.
thank you, Professor.
Yeah. So, okay, let's talk. So we've talked a little bit about the first portion of this chapter. Let me just emphasize that even though Dworkin rejects both historicism and pacifism, this doesn't necessarily imply that everything that we should go in the exact opposite direction. That we should say the intentions never matter when we're interpreting the Constitution. The intentions of the framers never matter. Because he thinks what matters is the thing they were trying to promote, the value that they were trying to promote in the Constitution. The Constitution's full of values for Dworkin. And we can infer what those values are sometimes by looking at what their expressed intentions were. It's just not that the intention is the only thing that matters. And in addition, we shouldn't always override the will of the people because there are going to be some situations where the will of the people simply does not conflict with our basic political rights as guaranteed under the Constitution. So we should not go in the far opposite direction where we say, like, the values present in the Constitution, the will of the people, and the intentions of the framers don't matter at all. What matters is the outcome of judicial decisions. Dworkin thinks the outcome matters somewhat, but what's more important is the values in the process, in the law itself. And if we adhere to those values, we will generally get good results. But it's only by adhering to those values that we can be sure that we will generally get good results. So he's not an activist either. And we'll see as we get into Bell next time. Some people are. Some people think, like people like Dworkin, they're liberals. Yeah, they reject these conservative views, but they're ultimately liberals in that they believe in the system. And some people think the system is fundamentally corrupt. It was built on corrupt principles. And therefore, even the values it expresses are nonsense or in some ways getting in the way of a full ultimate expression of human freedom. So we'll see with Bell what that kind of critique looks like. But anyway, let's talk about this Hercules thought experiment. So we're focusing on Brown versus Board of Education, which sometimes I feel like I should have you guys just read. But we're not going to focus. I feel like we hit on it from many directions already, and you guys know the basic holding of the case, so it's probably good enough. But anyway, the so he imagines this guy, Hercules, who's a Supreme Court justice, and he gets Brown versus Board of Education on his desk. People come in and give oral arguments about it. And he's trying to imagine how this guy, this imagined Supreme Court justice who is following the law and interpreting the law the way Dworkin would recommend, what he would do. So this is actually a pretty, I think, useful thought experiment, because sometimes it's kind of hard to tell from Dworkin's critique of things, and from like his abstract view of things, like how should this actually apply in the context of an actual Supreme Court case. So he gives us this thought experiment. So we've got this egalitarian idea he thinks that Hercules would start with, which is that government must treat all citizens as equals. That political decisions must display equal concern for the fate of all. So this, he thinks, is a kind of basic assumption built into our Constitution, right? So the question, though, is how do we actually apply that? Like that might be a value that's in our Constitution that might be expressed by the 14th Amendment. But that doesn't on its own, without additional reasoning, tell us which way the Brown versus Board of Education should come out. So applying Brown versus Board, what he thinks is, well, now I'm wondering if I should ask a question at this juncture instead of keep talking. Hold on one second. So there were three different kinds, and here I'm going to scroll off of this so you don't see it right away. There were three different kinds of, three different ways of dealing with Brown versus Board of Education. There are different suspect things, right? The question was like, this policy of school segregation appears to the plaintiffs to be unconstitutional and to the defendant to be constitutional. And the question is, how do we interpret this in line with the kind of basic egalitarian commitment that the 14th Amendment expresses, which is that the government ought to treat all people equally? So let's talk first about what he calls the suspect classifications account. What is that account? What does the suspect classifications account tell us? I'll put this up on the screen. Okay. The question was, there are three accounts of the basic right that mandates that some individual right not to be, that we have some individual right not to be the victim of state-imposed racial discrimination. But there are three ways of justifying that right, or explaining it, or accounting for it, right? Chloe's saying this is the hardest theory to understand. Yeah, okay, so maybe I need to say more just to make this clear. The idea is, we've got Brown versus Board of Education on our desk. We have to decide how to rule. He thinks somebody like his imagined Hercules would say, well, we start out with what the principle that the 14th Amendment expresses, which is that we have an individual right not to be the victim of official state-sanctioned racial discrimination. But there are three different ways you might interpret that value. And so Dworkin's got to give us an example of like, what would this interpretive process look like in a way that's actually action guiding? And he distinguishes three different ways we might look at this right that mandates some individual right not to be the victim of official state-imposed racial discrimination. Because this can mean different things. And the question is, what's the right interpretation? So let me just give you this. As far as suspect classifications goes, The idea is that the right against discrimination would only be a right, because we agree we have a right against discrimination, against official state-sanctioned discrimination. One view of this is that the right against discrimination is only a consequence of a more general right that people have to be treated as equals, according to whatever conception of equality their state pursues. So, anybody have a prediction? If we were to go with this account, who would win in Brown versus Board of Education? Yeah, Chloe?
So basically is saying that, so according to whichever conception of equality their state pursues. So at that time, the the Board of Education was trying to establish that the kids were still equal because they still were receiving education, even though, the levels of education was different. So it was still Board of Education would have won in that case, since according to the views of that time, that still was equality.
Yeah. Yeah, good. The idea is like, look, if your state thinks it's okay, thinks it properly treats people as equals to have segregation, well, then all you have really, the only right you really have from the 14th Amendment is you have an individual right not to be the victim of state-imposed racial discrimination. And what that means can be determined by the states. So the states have different conceptions of equality. What it means for people to be politically equal in Alabama in the 1950s is different from what it means to be equal, in California or New York. And so we might expect that these different states, pursuing somewhat different visions of what equality before the law looks like, will have different regimes. Whereas discrimination may be banned in New York, at least official discrimination, it might not be, or segregation might be banned in New York, it might not be banned in Alabama, because maybe the conception of political equality looks different there. Now, they both agree that political equality before the law matters, but one possible view is to say, yeah, but that gets a bunch of different into implementations, a bunch of different theories about what it is, depending on where you are, right? Okay, good. So that's one possible view you might take. Another is what he calls the banned categories view. So that this says that certain categories, including race, should not be used to distinguish groups of citizens for different treatment. So I will represent to you that I think what this would mean, if we were to look at the banned categories view, so institutions that use, let's see here. So on this view, if we are saying black people have to go to this school and white people have to go to this school, we're using race to classify people into which school they're supposed to go to. And the banned categories view is ultimately, I think, more or less where the Supreme Court lands in Brown versus Board of Education. They say basically that you can't use race. The state cannot use race to distinguish between people unless it has a really damn good reason. That's so they apply what's known as strict scrutiny to racial classifications. If the state's going to say black people get treated this way and white people get treated this way, that's a distinction on the basis of race, and there had better be a compelling government interest to justify that distinction. Anything that uses those classifications, that uses those banned categories, is immediately suspect, according to Brown versus Board of Education, the way that the court case ultimately came out. Okay, so that view, we go back here, the banned categories view, I think, would have to imply that the only way to uphold this right that people have implicit in the Constitution, because it's a value that the Constitution expresses, the individual right not to be a victim of official state-imposed discrimination, if the interpretation we're taking on that value is, well, look, you can't use certain categories to make these judgments, like race. Well, then that implies that Brown should have won, right? And that's ultimately basically what the reasoning was in Brown versus Board of Education. But we wouldn't be complete if we didn't consider this last possible interpretation of what this right I've highlighted on the screen means. And that's the banned sources view. It's not the view he thinks Dworkin doesn't think this view ultimately won the day in American jurisprudence, but he thinks it's a better interpretation of this basic right than the one that has really taken hold. And this is the idea that certain policy preferences are rooted in some form of prejudice and can therefore never count in favor of a policy that includes the disadvantage of one group. The idea is like the only real purpose, if we investigate why people have segregation, why Alabama had segregation, the only reason why it had that segregation was because of racial animus. That is, white people in the state wanted segregated schools, not because those segregated schools best upheld this right to political equality before the law that everybody believes in, but because they hated black people. And they wanted to make sure that black people were not with them in their children's schools. And that source of the law that ultimately was the reason why the law was passed is a banned source. That view, Dworkin thinks, is the best way to make sense of this idea that this principle inherent in the Constitution that people will have the right not to be the victims of official state-imposed racial discrimination. Because the idea is, anytime you're discriminating because you hate a group, that hate cannot serve as the legitimate basis of a classification system, right? That's different from saying that we cannot use race per se. That anytime we're talking about race, that can never be used as a way of distinguishing between people, because that wouldn't because that's the other way of potentially making sense of this. Okay, so let's talk a little bit about the why Dworkin doesn't agree with the banned sources or with the banned categories view. Because this is like kind of ultimately where a lot of American jurisprudence on the question of discrimination goes, is the idea like the government just can't use race as a reason to classify or as a method of classification of people. Well, what's wrong with that? That sounds pretty reasonable, right? Like people can't control their race. It's not like you can wake up one day and choose to be white if you're black or vice versa. Generally, we don't have control over these categories. And so the idea might be, look, don't discriminate against people based on something they can't control. Yumna is saying it didn't mention the injustice. It only focused on the category/race. It's an interesting point. So let's see. I think properly conceived of, the banned categories view does focus on injustice in the sense that it is an interpretation of what justice means in the context of equal rights before the law. The idea is like, look, we want to make sure everybody's equal before the law. Well, one way that people try to make people unequal is by distinguishing based on race. So we're not going to allow people to distinguish based on race anymore. That's the banned categories view. What's wrong with that, though? Yeah, Chloe?
Like in Mr. Is it Back? Alan Back?
Baki.
And like in Alan Baki's case, he was considered a majority. And like with affirmative action, with the policy that UC Davis tried to put in, that was to make sure that minorities still had a spot. So going back to why the banned categories wouldn't fit is because I feel like banned categories ignores the why these policies are in place, why racial discrimination in itself is such a big thing. It's not because of the categories itself, but because of that why, to make sure that those minorities are incorporated back into the majority when it comes to making decisions.
Okay. Yeah, I think you did a good job connecting it with this Bakke case. So the Bakke case is where you have this guy who sues UC Davis saying, hey, I should have gotten into medical school and you denied me a seat in medical school because I'm white and you gave it to a black person instead. And he said, look, I'm qualified to get into this school, and you rejected me basically just based on my racial classification, which is white. Well, under the banned categories view, what that means is, like, the banned categories view implies that Bakke's correct here, because the UC Davis was using race as a means of discriminating against one group of people in favor of another. They're using this classification, this category that is banned. And what Hercules would say, according to Dworkin, is, look, it's the best way of expressing this commitment to political equality before the law is not the banned categories view. It's instead the banned sources view. The best way to say that we have the best sort of principle we can use to interpret what it means to be equal before the law is that we shouldn't allow state actors to discriminate against people based on racial animus. But the policy that UC Davis had in place for affirmative action was not caused by animus against white people. It wasn't that UC Davis Medical School was saying, like, we hate white people, so we're going to let as few of them in as possible. The purpose was to try and remedy historical wrongs where black people were illegitimately excluded in the past simply because of their race. That purpose, notice, is very different from the purpose that drove the Board of Education in Brown versus Board of Education, where the purpose was not to make sure that black people got an equal education, but rather to ensure that black people were given a substandard education and separated from white people, because they hated black people. The racial animus drove, in that case, the policy. Whereas in this case, the policy is not driven by racial animus. So the source of the policy is different. Frankie, you're saying, I don't know if I've seen Shameless, but this reminds, I haven't seen Shameless. No. Hard to get DNA tested as part black to get into a military school. Oh, interesting. Yeah, I mean, there are all kinds of potential problems with affirmative action. I mean, I think there are other legitimate critiques of affirmative action, by the way. Like, in my view, people should be let into school based on how much they financially need it, in addition to how much how good their scores are. Because rich people get a huge advantage over poor people. Arguably, in many cases, more than, like, poor people are materially worse off as a class than any racial minority. It's not universal, but in any case, there's lots of potential. Oh yeah, and legacy admits. Yeah, I think those are pretty obviously affirmative action for rich people. Yeah, almost saying Students for Fair Admission versus Harvard ruined this. Well, notice, so Students for Fair Admission versus Harvard is a case where the classic line from that case, and it's only a few years ago that it was decided, comes from John Roberts, the Chief Justice of the Supreme Court now, who basically said the best way to end racial discrimination is to stop discriminating on the basis of race. Notice how that expresses a commitment to this banned categories view. It says, look, affirmative action, it doesn't matter how well-intentioned it is. It doesn't matter whether discrimination based on race is well-intentioned or whether it's driven by racial animus. All that matters is this is a banned category. The government isn't allowed to use this category to distinguish between people. Or at least if it does, it must have a very compelling government interest that would justify it. So that's Students for Fair Admissions is the sort of apex of the banned categories view. And what Dworkin would say is that gets it wrong. The purpose, the best way of expressing the value of political equality before the law is not the banned categories view. So let's talk a little bit about, in the last few minutes we have here, why he thinks this view is wrong. So a lot of times people justify the banned categories view by saying, look, people don't have control over their race. They don't have control over their sex. They may not have control over a lot of these other features that we usually say are banned categories. So, however, Dworkin points out, we make these kinds of distinctions all the time. So we subsidize workers who have a chance to come to work in one industry rather than another. The law also restricts driver's licenses or licenses to practice medicine, or the law for that matter, to people with certain mental or physical abilities. It affords educational opportunities based on conventional intelligence or athletic success. So these are things that like people may not have direct control over. Like whether you have a certain degree of general intelligence or not is not your fault if you don't. Like, but we all think it's okay for schools to let smart people in and not let really dumb people in. Like a lot of people think that. They think, in fact, it's an important feature of meritocracy that the best performers get the best chances. Well, a lot of times, much of what drives your performance are these things that are not under your control at all. And so we tend to say there are a lot of things that are not under people's control and yet can serve as the legitimate basis for the state distinguishing among people. So that can't possibly be the justification for banning race as a category. It can't be like, well, look, I don't get to choose whether I'm white or black. I just am one of these. And so the government shouldn't get to discriminate against me based on whether I'm one of these or the other. Well, the government discriminates based on innate traits or traits that are not largely chosen all the time. And we think it's legitimate. So this can't be the rationale, he thinks, for why we should. This rationale is clearly not applied universally throughout our society. So it can't possibly be the best expression of the idea of political equality before the law. So he thinks instead, and this is in support of his view that the banned sources view better expresses this value, that racial discrimination is unjust, not because people can't choose their race, but because that discrimination expresses unjust prejudice. That there's no reason, there's no moral reason, there's no value-laden reason to discriminate on the basis of race, where there might be value-based reasons to discriminate on the basis of other characteristics that again, people may not be able to control. So this view would basically end up saying that the affirmative action in the Bakke case should have been allowed. Should have been allowed because they're trying to solve this historical problem of injustice against Black people and other minorities in medical school. And that expresses a very different policy aim, a policy aim that's in fact perfectly consistent with our idea of equality before the law, even though it does, in the narrow sense, discriminate against people on the basis of race. It discriminates against white people, but it doesn't do so out of hatred for white people. It does so out of a desire to remedy past historical injustice. So this is like where Dworkin departs from contemporary Supreme Court jurisprudence on this kind of issue. Of course, you should see this as just like one example. He's used this Bakke case and Brown versus Board of Education as just examples of how we can apply his broader notion of constructive interpretation to the Constitution. The broad idea is we figure out which basic values are inherent in the Constitution, like the ability to freely express yourself, right? The ability to have a religious point of view, the ability to, not, or the right not to incriminate yourself when dealing with the government, or the right to not have your house sieged or searched without a good reason. These are like basic rights that we have that they express certain basic values of maybe privacy and free expression and other things like that. What matters is not what the intentions of the framers were when they tried to write this. What matters is what values were they expressing, and how do we best give expression to those values today in the society we exist in now? So this is an example of how he thinks we can try and find expression for these values using one of these values he thinks is present in the Constitution, which is this idea that we should have the individual right not to be the victim of official state-imposed racial discrimination. There are a bunch of possible ways of trying to realize that value. And he thinks these other two ways, the suspect classifications one and the banned categories view, these do not properly account for the right that we think we have under the Constitution, the principle or the value that the Constitution expresses. And this other one does. So this is like, if I'm trying to sum up maybe all the stuff we talked about in Dworkin, if we're trying to apply this to when you write your papers, you're going to be looking at a Supreme Court case. You're going to be telling me what's going on in that case, and you're going to be applying Dworkin's idea or Bell's idea or Hart's idea to that case. And you have to tell me basically what would they have thought and who was right. And this is the way I want you to do it, right? When it comes to Dworkin, what's the value that's present in the article of the Constitution that this Supreme Court case is about, or the amendment to the Constitution this is about? And what principle best expresses that value, like in the context of this particular problem, right? That's the kind of pattern of reasoning I want to see when I come around and see you analyzing something through Dworkin's lens. All right, we're out of time. Hopefully that made some kind of sense, guys. For next time, we're going to start up with Bell, but we have like 2 weeks of break here because our class happens, both our next Thursdays are in spring break. So enjoy your spring break. If you guys have questions about anything in the class, please let me know. Let me make sure, when is the case study due? It's due on the 30th, so we'll have some time after we get back to talk about that. Yep. All right, guys, I will see you guys next week. I'll stick around for questions.
Thank you. Have a good night.
Good night.